I knew when the doctor threw a tantrum in the middle of his deposition, threw his papers down, and stormed out of the room. I knew at that moment we had won the case. You want to know what this is all about? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, this was a medical malpractice case. It was actually a plastic surgery case. And now, this doctor claimed that he did everything appropriately. My client suffered significant harm and injury as a result of an elective plastic surgery procedure. And as a result of what occurred during this procedure, my client was severely and permanently deformed, disfigured. She required multiple surgical corrections that did not solve the problem. She had now a permanent, lifelong injury. Now, I had multiple medical experts review this case who confirmed that my client did in fact have a valid case. They confirmed that this doctor, this plastic surgeon who treated my client, departed from the standards of care. And as a result of those departures, of that carelessness, my client suffered significant harm and injury. Now, during the course of the lawsuit, my client was questioned in a process that we call a deposition. That's a question and answer session that takes place in my office, in our conference room, and now there's a court stenographer there to record all of the questions and all of the answers that are given. The answers that are given represent my client's sworn testimony. That took an entire day in this particular case. Now, a few months later, I had an opportunity to go ahead and question this plastic surgeon in this particular case during a deposition. This was done in his attorney's office. What was fascinating to me is that this plastic surgeon showed up wearing sweatpants, as if he had just come from the gym. Now, I will share something with you. It's an observation I've made over the course of many years handling these medical malpractice cases. The plastic surgeons tend to be the best dressed physicians I have ever seen. They're always looking to impress. They always think that your appearance is so critical and important. Yet this guy came to his deposition, which is a critical component of any medical malpractice lawsuit, dressed like a schlump, dressed like a schlemiel. That's a Yiddish word for basically saying he just didn't care how he looked, which is unusual because the materials that he had on his website and his photographs to show and how he held himself out to his patients was that he was a meticulous dresser, very focused on appearance, but yet during his deposition, he didn't give a damn. He didn't care. So he came in wearing what appeared to be a sweatshirt and sweatpants, and now he sat down. And during the course of the deposition, it became clearly evident to me that this guy was intolerant of my questions. He kept asking me how I had the nerve, how I had the gall to be questioning his judgment. And you know what? It was fascinating to me that he was so defensive. If he truly believed that he did nothing wrong, there would be no need for him to be so defensive. He was so angry and upset that here I was, an attorney representing a damaged, injured medical malpractice client. And now, instead of focusing his anger on his actions or his inappropriate actions, instead he was focusing his anger on me, the attorney who was questioning him. What's really interesting is that it is not me who's deciding whether or not this doctor did something wrong, but rather it is my medical experts who have confirmed and validated that this doctor did in fact improperly treat my client. And he should have known that because he had been sued in the past. He had been through this process before, and I knew he had been sued in the past. And he had paid out money in the past to other patients. So that was just one inkling to give you an idea of the tone and the tenor of what went on during the course of this question and answer session. Now, here's something interesting that you may not realize. During the course of a deposition, when the court stenographer is taking down all of my questions and all of the doctor's answers, they cannot capture the tone and the essence of how those answers are given. They cannot capture the level of the doctor's voice. They cannot capture whether he's being polite, whether he's being nice, or being nasty and arrogant. None of that comes across in the written word. So if you were to pick up a copy of the transcript, those questions and those answers that are now transcribed after the doctor has finished testifying, and you were to read all those questions and answers, you would just be seeing sterile questions and sterile answers without having the benefit of knowing the undertone of what actually occurred during the course of that questioning. Who would know? His attorney? I would. The court stenographer would. But it doesn't come across in the deposition transcript. So this undertone, this anger, this hatred, you could clearly see it during the course of this deposition over a number of hours. And then it reached a boiling point. I asked him an opinion question. Doctor, would you agree, based upon these facts, that if X, Y, and Z had not been done, that would be a departure from the standard of care? And now you should have seen the steam coming out of his ears. You should have seen how red his face got. How dare I start to question him and now ask him whether his actions represented departures from the standard of care. He got so angry he started raising his voice. Dramatically, significantly, he started yelling. He stood up, he started screaming. You know, like when a 2-year-old throws a tantrum, they start pounding their feet and they start bouncing up and down with their hands and they make gestures and then they storm out of the room? That's exactly what this doctor did. He started screaming and yelling. He started stomping his feet. He started gesticulating and articulating with his hands. And he took his paper in front of him. He threw it down on the table and then stormed out of the room. You should have seen his attorney, his mouth dropped open, and he quickly jumped up and ran out of the office, ran out of the conference room to chase after his client. I have never seen that in all my years of practice. I had never seen anything like that. The court reporter was in shock at what she just witnessed. And I turned to the court reporter and I said, in the course of your career, have you ever seen a doctor act like that? She said, I have never, ever seen a doctor act like that. She said, this guy is so wrong, and you can clearly see it in his face. And you know what? She was absolutely right. And I knew at the moment that this doctor threw his tantrum, I knew that this case would never get to trial. I knew that if this doctor ever got in front of a jury, this is the type of nonsense that I would be able to use to show to the jury that this guy was manipulative, that this guy clearly departed from the standard of care. He had no basis upon which to act like this. This was totally unprofessional and uncalled for. And all I'm doing is my job by asking him questions. These are just words, and now he just has to answer these questions as he's required to do. So when the defense attorney came back into the room without his client, he basically told me, listen, we should start talking and trying to settle this case. Now, the interesting thing is that we never went further than that conversation about trying to settle that case, certainly around that time. However, a few months later, I received information that this doctor had lost his medical license. In fact, I should rephrase that. The New York State Department of Health had revoked this doctor's medical license to practice in the state of New York. Why? Because they determined that he was an imminent danger to his patients. Was it because of my client? Not entirely. It was because of a number of other patients, and he was under investigation by the New York State Department of Health. And coincidentally, while our case was proceeding, they had reached their conclusion that this doctor was clearly a danger to ongoing patient care, and they immediately revoked his license. Now, how does that play out in terms of settlement negotiation or going to trial? I knew that together with this doctor's attitude, his horrible attitude, that he would never get to trial. He would never take the witness stand. And I knew that no matter how much bluffing his attorney did, there was no possible way he was going to put his client up on the witness stand and have him testify. So what ultimately happened? We did settle the case a number of months later, but that was a fascinating insight into something that I'd never ever seen before. A doctor threw a total tantrum, and then I knew right then and there this case was never going to trial. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of medical malpractice cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.